All right. Good evening, everyone. We at the Society for Excellence in Arbitration Law welcome you all to our webinar on reassertion of control by host states in investor-state dispute settlement. This webinar is the third webinar of our online lecture series on contemporary issues in arbitration. The chief patron for the webinar is Professor Subir K. Bhatnagar, who is the Vice Chancellor of RMLNLU Lucknow. Dr. Prasanjit Kundu, who is the Assistant Professor of Law at RMLNLU, is our program coordinator. I am Rashika Bajpai and I will be your moderator for today. Now, without further ado, I would like to introduce our stellar panelists. Although I would add that our panelists do not need any introduction, but I'm sure that most of our viewers are here only to listen to these celebrities of arbitration world. Uh, we have with us uh, we have with us Mr. Ben Giaretta, uh, he is an international dispute resolution lawyer, a mediator, and also a chartered arbitrator based in London, and he also chairs the Chartered Institute of Arbitrators. He is the partner of dispute resolution at Mishcon de Reya. We also have with us Mr. Harshad Pathak, who is a senior associate with PNA Law Offices. He's an Indian qualified lawyer with commercial arbitration, investment treaty arbitration, and civil litigation as his core practices. He is an alumnus of MITS Geneva and also National Law University of Delhi. We were supposed to have Mr. Nakul Dewan joining us today for the session, but due to certain technical problems caused by heavy rains in Delhi, he was not able to join us today. But instead, we have Mr. Rohan Nayak, who is an associate of Mr. Nakul Dewan, and Mr. Nayak graduated last year and has since then worked on a lot of arbitration related matters. So we thank all of you for taking out the time to address us, and we're looking forward to an engaging and enriching experience. Also, the participants are encouraged to ask questions, and they can do so by typing their questions in the chat box below. They can also specify if they want their questions to be addressed by a particular speaker. I think we should now set the ball rolling for the discussion. The ISDS regime, initially designed to balance investor rights with host states' right, has now become a point of controversy and backlash. And the host states have started to believe that this regime is imbalanced and restrains their sovereign power. So, because of this, they are increasingly challenging the system. As a consequence, we see states frequently bypassing the regime by either opting out of the BITs or reforming the existing ones. We've seen states advocating for domestic remedies and also appeal mechanisms to the investor state arbitrations. And in the current webinar, we intend to conduct an interactive session revolving around the procedural and substantive techniques by which states developed or developing reassert their control over the interpretation and application of investment treaties. So in this light, my first question to you, Mr. Nayak, is that what are the reasons behind the move of the states away from the ISDS mechanism?
Well, initially, when it comes to resolution of disputes between states and investors, prior to most of the modern bids that were entered into, you had exclusive state-to-state dispute resolution mechanisms. It's only post 1969 where you see investors being given a procedural right to initiate disputes without needing their states to espouse their claims for them. Of late, you're seeing a reversion to that early trend, and a possible explanation for that is the perceived bad experiences of certain developing countries within the realm of investment arbitration. So which would probably explain the need for them to reassert control over the mechanisms through which disputes are resolved, thereby cutting out the investor's procedural rights to initiate a claim altogether.
Sir, can you elaborate on the different kinds of alternatives or solutions which have been suggested by the states to counter the ISDS mechanism? For one that I know is that UN Citral came out with a working paper which might have implications for the ISDS regime. And what is the take from this working paper? Is it in favor of the ISDS regime, or is it trying to push the regime back?
Uh, so, from my knowledge, the UN Citral working paper has tended to be very receptive towards alternatives to the investment arbitration regime because they recognize the tendency of states to move away from that regime. Uh, an important cue was taken from the European Union in this regard, where the European Union has, in its investment agreement with Canada, set up a specific investment court system, which is very similar to the WTO dispute resolution mechanism, where you initially have a quasi judicial inquiry on facts and law and then an appeal purely on law. So the UN Citral Working Group has taken note of this trend towards uh, having mechanisms for dispute resolution that are not your normal mechanisms seen within the investment arbitration world. And the UN Citral Working Group has seemed very receptive to these alternatives, but a lot of the creases are still being ironed out. For instance, there is no clarity on how judges would be appointed or how such a project would be financed. But notwithstanding these logistical hurdles, there is a definite move towards establishing an alternative to the current system.
All right. Thank you, sir. M- an immediate question comes to my mind with what Mr. Nayak has said. Mr. Giaretta, can you take this question up? My question is that I mean, we know that the mechanism is burdensome for developing countries, and we will discuss the aspect shortly. But what is at stake for the developed countries, and why are they also providing a substantial push against the ISDS regime? And what are the steps that these developed countries have taken? And what I know is that EU has been pushing against the ISDS regime and has also proposed the multilateral investment code, which is discussed in the UN Citral working paper.
Yes, thank you. So there's a number of things going on here. Firstly, one has to remember that a lot of the early BITs were relatively simple. I mean, they would only be 6 or 7 pages long and have quite broad clauses in them because they were intended as political documents rather than legal documents. And when one takes the rather simple approach in those documents and brings them into contact with the complexities of the world, you can see that there may be quite a lot of unintended consequences. I mean, the development of indirect expropriation is the most obvious one, because to a layman, reading an expropriation clause in one of those early simple BITs, one would only perhaps be thinking of, if you like, soldiers going in and taking over an asset. But of course, as we've seen over the years, it's been applied to so many other situations, and validly so. I'm not criticizing it. I'm just saying that the development of these BITs, because there's been so little in them, has been rather unexpected. And as a result, you've seen the more sophisticated BITs become, so the more recent BITs become more sophisticated and having more detail in them. A second factor that's going on here is the clash of the public and the private. Public administrations throughout the world, some of them can operate very efficiently, but some can be quite poor in their administration. And as a result, they can make mistakes both in the way they approach the original measure, which is the subject of the complaint in a BIT, but they can also make mistakes when they approach the running of the arbitration. One sees some governments defending claims in quite a poor fashion, one might say. But of course, whereas on the other side, the private companies, some of them have not approached VAT claims very well either, but they have tended to be better run than some of the public bodies. That's a huge generalization, and there was lots of detail in that statement, but you'll get my overall drift here as to the way that people have become unhappy with it. And the third point is the fact that these arbitrations have, until recently, tended to be confidential or at least private, so that people cannot access them very easily. And as a result, they've been easy targets for criticism, because people have been saying, well, this is secret justice, it's done by private judges behind closed doors, and it's criticizing our duly elected officials. And that's a very difficult thing for the public and for politicians to accept. So it's all this combination of various factors that have brought us to where we are today. And you go back to your original question about the richer countries in the world. Well, they found themselves on the sharp end of this process themselves. I mean, there have been claims against many European countries now, not many claims against each one, but many of them have faced claims. So Germany's faced claims, Britain, US, Belgium, etc. And as a result, these processes have become very political, and we're now seeing a backlash against it. In particular, as you've mentioned, there have been developments with UNCITRAL, with new reform measures that are being proposed. There has been a move within the EU to cancel BITs, at least between the European countries, and referring things instead to the existing judicial system that is within the EU. Now, whether these methods are any better, it's hard to say. I mean, there's arguments both ways, but they're more public, and as a result, what it is to be hoped, I believe, that there will be greater confidence in the system going forward.
Thank you, Mr. Giaretta. Although there is a follow-up question that comes to my mind. We know that most investors are from these rich developed countries, and then also we see that these developed countries or home states are advocating against the system of providing investor protection now. And why are these countries not thinking more like a home state and thinking like a host state now? And the reason I say that is because there recently, like I read somewhere, that United States Mexico Canada agreement, which it will now from the year 2023, it will limit the scope of protected investors, and it will also prioritize some investors over the others. So it is a reversal of the US investment protection policy as was previously outlined in the NAFTA and also even in the post-NAFTA agreements.
Well, I mean, I think the key word is policy, which is related to politics. I mean, this is all about politics, and it's about the prevailing political stripe of the government of the day. So the Trump administration is relatively protectionist, not as much as in some countries throughout the world, but more so than in the past. When there are future governments in the United States, their trade policy will change again. I mean, that's the other key element to all of this, that this is about politics. I mean, what one talks in terms, says, well, this is all about justice, whatever. Well, that's only half the story. This is also very much about politics. And yes, I mean, the world is becoming a more protectionist place across the board.
Mr. Pathak, would you like to add something to what Mr. Giaretta said? And also, if you could give us an insight to the steps that have been taken by the developing countries. I know we will discuss the Indian perspective extensively in the later segment, but could you tell us about other developing countries like South Africa, Brazil, Argentina, and how do you think that these countries feel about the multilateral investment code that was proposed by the European Union?
Right. I think the first aspect is to realize that different countries will have different expectations from ISDS mechanism, and these expectations themselves will not be static. They will continue to evolve depending upon their experience. For example, you mentioned Argentina right now. Now, Argentina was one of the Latin American countries which did, once the Calvo doctrine movement subsided, it did sign a lot of bilateral treaties. But when the peso crisis happened in the early 2000s and the numerous cases that were filed against it, it did defend a lot of these arbitrations successfully. But a number of these cases, the particular line of jurisprudence developed by investment arbitration tribunals, where the doctrine of necessity, for example, was interpreted narrowly, it left a bad taste in the mouth, because of which Argentina felt cheated. Argentina thought that its domestic interest, its economic collapse, were not being adequately taken into account by ISDS tribunals. And therefore, after that experience, you saw Argentina, you saw countries like Bolivia, Venezuela, lost a lot of trust in the investment framework. Now, the loss of trust was not linked to a specific form of arbitration or a World Investment Court, but a lot of it engendered a lot of conversations about legitimacy. There was doubts were placed whether the ISDS framework and the actors involved, particularly the representations from the global South or Latin American region, whether these issues are the ones which do not allow investment ISDS to take into account the interests of Latin American countries. Now, it's not a question about whether there's a World Investment Court or there are ad hoc or institutional arbitral tribunals. If these problems continue to persist, then it would be difficult to say that many of these countries would retrust the system despite their previous experiences. They may, for example, prefer regional blocks, regional conventions. They may prefer having a domestic law for protection of investments, or some of them may lose trust. Like reform of ISDS is one approach, but abandoning the ISDS is an approach that in many parts of the world considered legitimate. So the expectations of these individual countries would determine whether ISDS framework regains their trust or not, and there cannot be a static answer to that, I believe.
Thank you, Mr. Pathak. There is another interesting trend that is going on, which is the shift from investor protection to allocating investors certain responsibilities that this trend has been seen. And as the first example that comes to my mind is the provision of corporate social responsibility in Brazil's CFIA. So, what are the other obligations the countries are putting, and is it a trend only in the developing countries, or this has been followed by the developed countries as well?
Well, again, I mean, the paradigm of developed dynamic needs to be looked at here, because I think it's a wonderful article by Thomas Schultz which maps how over the past decade or so, increasing number of cases have also been filed against countries which you would say are part of the North Bloc. I think Ben referred to Vattenfall versus Germany, one of the cases, which has caused a lot of problems for Germany as well. So the point here being is that the root cause for introducing provisions which place obligations upon investors come from the way ISDS framework has evolved. It was perceived that there is a power differential between a foreign investor, an alien, and the on a massive state with all its police powers that were in place. ISDS was meant to restore that equilibrium and create a level playing field. Many perceive that it has done that, and it's gone 2 steps ahead and now created a new systemic bias or preference in favor of investors. And it's in order to balance that now the modern age, I think Netherlands model BIT, Indian model BIT, they are encouraging provisions. It's not like they've been successful in entering into treaties, but they're encouraging provisions which place reciprocal obligations, particularly with reference to human rights on investors as well. CSR is an indirect way of providing for such obligations. I think one of the common ways is to say that the investment is made in accordance with all applicable domestic laws of the host states. So, for example, in the Indian context, now all the coastal regulations would become a part of this, that each and every domestic law that obligates an investor, for example, to make their investment in a manner that respects the rights of the citizens of the host state. The objective is to bring these rights within the treaty ambit as well. But it's a very nascent movement, and there are a lot of roadblocks ahead.
All right. Thank you, all the panelists. Let's now come to the section where we discuss the COVID-19 scenario. And it is a tough time for all the countries, and they're taking several actions to avert the pandemic. So, in this light, Mr. Giaretta, can you tell us about the issues that might arise out of the actions of the state? And can the host states reassert control and get away with it? How do you think that the states might negotiate the investment agreements, knowing that emergency situations like these can be more commonplace now?
Thank you. So it's a very complex situation that we're all in. And of course, we have to acknowledge the very severe health impact on everyone. But we're just talking about the legal remedies, the legal claims that might arise out of it. But it is very complex. It's also very novel. So there's no. I mean, it's a novel disease, but it's also a novel situation that the world finds itself in. So it's difficult to predict what might happen. But let me, in a way of trying to make sense of it all, let me propose three broad categories of behaviors by government during this time, which might attract claims under investment treaties. And I should also caveat this by saying that, of course, there are some variations in investment treaty wording. So one would have to look at the specific investment treaty to work out whether there was a possibility of any of these claims arising. So I just want to suggest three broad groups of behaviors by government at this time. The first is the actions that governments are taking in relation to public health. So, for example, in Britain, we've had some emergency hospitals that have been set up. There's investments in vaccines. There's lots of other steps that have been taken by government directly relating to public health. And I'm sure there are many in India as well. Now, these might give rise to investment treaty claims. And that can be looked at in a few different ways. You might have investors claiming that these actions are discriminatory in some way against them. You might have some investors saying, well, governments have not done enough to protect the security of the investments and to protect the security of the people employed by those investors within the country. You might also have investors complaining they've not been given sufficient compensation as a result of the government's actions in public health sphere. So I can see some possibilities of claims there. However, I think that many may not arise in practice, and if they did, they may not be successful. And that's because they may not arise in practice because I think many investors would be very wary about making claims which could be so easily criticized, and they would suffer considerable reputational damage if they went down that line. I mean, if you're criticizing a government for setting up a hospital to save dying people, I mean that would be an extraordinary action for any entity to take. There are also a number of ways in which governments could defend those claims. Under the newer BITs, there are very often carve-outs for actions related to public health, so that no claim would arise if the action is directed towards public health measures. Under the older BITs, one might also raise defenses such as necessity or force majeure under international law. So for a whole number of reasons, I don't think we'll see many claims arising out of this first category of actions by government. But let's move on to the second action, which is the economic actions. Because of course, this is not only a public health crisis, it's also an economic crisis. In Britain, just as in India, many people have been locked down, have been stuck at home, and this has caused an enormous impact upon the economy. And as a result of the economic impact, government is now taking various steps to stimulate the economy again. Now, that may well give rise to more, there's a greater possibility of investment treaty claims there, in particular because governments may well take actions that are directed in a particular way. They may want to support their own national industries more than foreign industries. They may make certain political decisions about which industries to support. There may, for example, be many grants available to the aviation industry, which is particularly badly hit at the moment, but fewer grants for other industries. And you could then get investors saying, well, why are we being discriminated against here? This is not, and there wouldn't be any defense there of public health. This is purely in the economic sector, the economic actions of the government. So I can see quite a number of claims arising there. And the third category is what I might call disguised public health actions. These are actions that may apparently have been taken as a result of the pandemic, as a result in order to protect public health. But actually, if you dig down into it, there may be some other reasons why the government is taking this action, some nationalistic reasons. Some we talked earlier about the way that governments are becoming more protectionist. Well, one could well see that you may have an action which in normal times will be seen as very protectionist, being disguised or misinterpreted as a public health action. So you may get, although I said in the first category you wouldn't get many claims, you may get some companies bringing claims in the hope of digging down into the reasons why government has taken a particular action, taking over a particular building, apparently for a public health reason, or imposing restrictions. I mean, there's been discussion about what might happen in Peru, for example, where they are suspending tolls on toll roads. I mean, if one digs down into the motives of this, it may well be that there were some other reasons the governments are taking this action which aren't related to public health. And so you may get claims in that category as well. So that's how I could see how it arising. So I can see many claims arising. It won't be anytime soon. It's likely to be into next year once things have settled down a bit more. And I should also say, with the increasing amount of funding available for investment treaty claims from litigation funders, I think you'll see many more companies wanting to explore these options and eventually bringing these claims as well. And I think that those will be claims against developing countries and against wealthier countries. I can't, because they've all taken these actions, so I can't really see any of them not being exposed to the likelihood of these investment treaty claims.
That was an interesting perspective to investment claims arising out of the pandemic, Mr. Giaretta. I just have one question for you. In face of the current crisis, the European Commission around end March, called upon its member states to make full use of their existing FDI screening mechanisms, or in the alternative to set up a full-fledged screening mechanism to cope up with the increased potential risk to the EU strategic industries. Now, whether foreign investors enjoy any protections under such international investment agreements in case of exclusion due to discriminatory or abusive use of these screening powers granted to host states?
Because of, sorry, I didn't catch that question. So they.
So my question is that what are the claims that the investors can bring against the countries in the European Union with regards to the FDI screening mechanism that they have put in place? And they have said that the countries can, yes.
Well, I mean, it is perfectly possible that a particular investor may feel that they've been discriminated against and may bring claims arising out of the European Union's actions, or it may be under an investment treaty, or may be rising under the treaty the European Union as well if they are EU countries, sorry, EU citizens. I mean, there's been attempts to diminish the possibility of investment treaty claims. I don't know if you were about to ask about this. There was this proposal that BITs be suspended for the time being. I don't think that request is necessary at the current times. I don't think any investor would bring a claim at the current time. I think now is not the right time to be bringing these claims. But next year, I think we will start to see some claims, assuming, as I hope as everyone hopes, that the public health emergency will have decreased by then. But I think once we're into that phase, we're into the next, over the worst of this pandemic, and people are starting to get back to normal, we will see some claims arising out of what has been done during this pandemic period.
Thank you, sir. Mr. Nayak, would you like to add something to that? And also, I have an additional question for you. That and it's related to India. During the pandemic, there were certain e-commerce platforms which were not allowed to sell non-essential commodities, which independent shops were allowed to in fact sell. So, do you think that this distinction has can be a ground for any sort of claims against India? And also, we know that the grocery stores in shopping malls were closed, but independent shops were still allowed to function.
Rashika, you'll have to clarify that question. I didn't get it. Rashika, could you?
Yes, sir. So my question was that there have been certain
e-commerce. Please repeat the question.
Yes. So my question was that there have been certain e-commerce platforms which were not allowed to sell non-essential commodities during the time of the pandemic, but there were independent shops in India that were allowed to function irrespective of this sort of distinction. And also we know that in shopping malls, the grocery stores and such stores were closed, but again, independent shops were still functioning. So do you think that this is a very small incident, but do you think that this can really affect any sort of investment agreement?
I would think not, because for one, as Mr. Giaretta pointed out, there is a significant reputational risk associated with bringing claims during the time of this pandemic. It would seem a bit absurd for people to assail the Indian government's measures in this regard, because if you were to reevaluate the measures, you would notice that the platforms or the forums that were prevented from selling goods were those which either involved the transport, involved people commuting from place to place, or the congregation of a large amount of people at a certain space, both of which were not were contrary to the guidelines on how to avert or how to contain the spread of this pandemic. So one, on that account, and secondly, piggybacking on Mr. Giaretta's point of the reputational risk associated with bringing claims in during such a time, I wouldn't think that these measures would impact or would lead to any claims being brought against the Indian government during this time.
Thank you, sir. Just one more question on this segment, and then we'll move ahead to the next segment. This question is directed to Mr. Pathak. And Mr. Pathak, can you explain the effect of this pandemic on force majeure force majeure clauses in BITs or other investment agreements, or do you think that a force majeure claim can be brought against the government? In fact, can the government take this defense?
Right. Well, the possibility of government taking this defense of force majeure is it's quite high, and especially there have been circulars issued by the ministries in the past classifying specifically for the purposes of governmental contracts, recognizing the pandemic as a particular force measure. While this by itself is certainly not determinative, it certainly gives a lot of force to the argument of force majeure that may be taken. But in all of this, what is overlooked is, I think what both other panelists rightly pointed out, is especially that's a unique characteristic of investor state disputes, that in most cases investors have an incentive to maintain good cordial relations with the state so that it could continue its investment on favorable terms. At the same time, states also have an incentive to have one, first, vis-a-vis a particular investor, maintain cordial relations so as to attract further investment and to preserve its image in the international community as an investor friendly state. So in many of these contracts and even the BITs, they provide for an amicable dispute resolution, a pre-arbitral step. In the context of a pandemic, where there are ample reasons for someone to understand why measures may be taken, I believe that even a dispute starts in a gradual manner. It starts with a notice of dispute being sent. So I would like to believe that even if there are certain grievances on part of investors, and even if there are imperfections on part of the state in taking either public health or economic measures, once the dispute starts, it would be possible to talk it out and arrive at an amicable solution in a far more conceivable manner than it would be in a pre-pandemic situation or completely or measures that are unrelated to the pandemic. So it's not purely a legal issue at stake here, but it's also, I think it's about the politics of it, it's about the commercial prudence of it, and at one level it's also about diplomacy involved in ISDS disputes.
All right. Thank you, panelists. I think we should move on to the next segment on reassertion of control through state-state arbitrations. And Mr. Nayak, over to you.
Yeah, as I had mentioned in the beginning, state-to-state arbitration isn't something that's particularly new. It's how protection of investment originated when treaties were entered into between two states in order to encourage investment interstate. You 1969 onwards, you see investors being given the right to initiate claims by themselves rather than relying on on their host states to espouse claims on their behalf based on the doctrine of diplomatic protection. Uh, However, investors were given these rights, you didn't really see an expunging of the state-to-state mechanism, so that the investor-state mechanism continued in parallel with the state-to-state mechanism. So a lot of times the state-to-state mechanism proceeding as well as the investor-state mechanism, and there were certain two cases which are relevant in this regard. One being the Peru Chile case, where an investor state proceeding had commenced and subsequently a state-to-state proceeding was undertaken. However, firstly, most of these treaties never really provided for a hierarchy in which these two mechanisms were to operate. So it was left to the tribunal to determine the impact of one proceeding on the other. And while both the tribunals didn't really lay down a standard as to when one proceeding would impact the other, they didn't rule out the possibility of both proceedings continuing in parallel. But you're still left with a significant hurdle as to how you would interpret one tribunal's findings on the treaty with respect to the other proceedings. This is likely to be less of an issue now as you see states moving towards a more state-to-state arbitration model, the India-Brazil BIT being a case in point. However, you also, apart from these state-to-state arbitration models, you do have certain other mechanisms through which disputes are resolved. For instance, the ICJ is a forum for dispute resolution in certain treaties. You also have regional courts in certain other treaties. And as I had mentioned earlier, certain quasi-judicial mechanisms similar to the WTO dispute settlement mechanism as well. However, when you go into the realm of state-to-state dispute resolution, mechanism, there might be a tendency for states' political interest to come in the way of dispute resolution on behalf of the investors, because if a treaty provides only for state-to-state dispute resolution, the investor does not have a right to initiate disputes on its own. It relies on the state espousing its claims in order to uh, claim against the state which has taken away its rights. So, if a state chooses not to initiate a dispute with another state for political reasons or for any other reason for that matter, the investor is left without much recourse against the state in which he had invested. So, while there is a tendency for host states to reassert control over the investment that has been made in them, it does leave investors struggling a bit as to how their investments would be protected should political considerations trump resolution of investment disputes.
Thank you, sir. I do have some follow-up questions for you. My first question is that can there be an amalgamation of state-state arbitration mechanism and investor-state arbitration mechanism without one overpowering the other?
Uh, Interestingly, yes, there are two specific treaties come to mind. One is the China-Singapore BIT, and the other is the Canada-Venezuela BIT, where proceedings under one mechanism can continue without prejudice to proceedings under the other mechanism. Uh, an outlier in this regard is the ICSID Convention, which says that there cannot be a diplomatic protection claim once an investor state proceeding has commenced. And certain other treaties as well also bar state to state arbitration once an investor state arbitration has commenced. You have the US Turkey BIT, the ASEAN China BIT, as well as the ASEAN investment agreement, where once an investment arbitration has commenced between an investor and a state, there is a bar on other proceedings continuing in parallel.
Thank you, sir. I have certain questions relating to the interpretation claims. And my questions are open to all the panelists, and anyone can volunteer to answer them. So my first question is that can these interpretation claims in investment agreements between two states, under those agreements, can interpretation claims be used to influence the outcome of an ongoing investor state dispute, given that both mechanisms for dispute resolution is provided in the investment agreement? And also, can it assert control over enforcement mechanisms? And it can challenge the finality or the validity of the award that has been given by the investor state tribunal. Can can anyone answer that question?
Sure. I'd be happy to take the question about states using the enforcement or annulment mechanisms. Now, much would depend upon whether first it's an ICSID arbitration, because if a country is signatory to the ICSID convention and the arbitration takes place under its aegis, then there is no judicial supervision by national courts that's permitted, at least at the stage of setting aside or annulment of an arbitral award. There is, however, a mechanism for an ICSID ad hoc annulment committee being constituted to review whether the award passed by an arbitral tribunal was valid or not, and there are certain narrow grounds. So it's not a de novo review of its correctness on a whole. Barring these exceptions, the problem that comes is most host states would prefer to have the seat of arbitration for their non-ICSID arbitrations in their home jurisdictions, so that if an adverse award is passed, then it's their own courts which have an opportunity to look whether these awards are valid, and that will have then further implications on the enforcement mechanisms. But that rarely happens. There is I don't recall a single instance. There may be a few aberrations where an investor would readily agree to have the seat of arbitration in the same state where it's made an investment against, in the same state against which it's fighting. But there are instances where, so countries like Singapore, London, Geneva, Hague, these are the popular neutral seats. There are instances where, for example, in the UCOS case, at the first court of appeal, I think it was that, where the Hague Court did set aside the award on, despite the narrow grounds provided under Dutch arbitration law. So by agreeing to seats which are more permissive for a successful challenge and which do not rush to uphold the validity of investment awards, that is one very limited but a possible way in which states can try to reassert control or take back control over ISDS proceedings. And it's with that intention that countries like Bolivia, Venezuela renounced from the Exit Convention in 2007, so as to get away from the in-house mechanism of checking the validity of investment awards.
Thank you, Mr. Pathak. Let's now move to the Indian perspective. Does any other speaker want to add anything to this segment?
Well, just to highlight again the fact that we are talking about politics here. So any of the actions that you've described will involve a political decision, and a political decision both in the sense of it being picked up by the media within country, but also picked up by the media of other countries. I mean, for example, if India wanted to change something involving its BIT with Brazil, which has just been entered into, the Indian government would attract comment both within India and also in Brazil, and plus in other countries as well. So, I mean, these steps may be available to politicians or to governments. I hesitate to say that they are. I mean, there seems to be very narrow grounds for some of the actions you suggested, but whether they will be taken in practice is another question entirely. And I think in practice, any government will be very anxious about taking such steps because of the political implications of it. I mean, one looks at the criticism of ISDS tribunals now, which has been made by governments, and you think, well, sometimes people in governments would quite like these decisions to be taken by private tribunals. It suits them because then they can blame someone else if something goes wrong. So.
Thank you, sir. Let's now move on to the Indian perspective in regards to the ISDS regime. Mr. Pathak, can you please shed some light on the issue?
Sure, happy to. So the Indian perspective, I think, and one of the themes that was discussed initially was India and its protectionist outlook towards ISDS. And in this context, it's often argued that what is meant by protectionist is that a state has an anti-foreign investment or an anti-foreign investor or an anti-ISDS sentiment. In the Indian context, reference is ordinarily made to 2017, where India unilaterally terminated some 58 odd BITs. And the argument goes that as far as international investment law is concerned, India's outlook is protectionist, or there's a backlash against ISDS. Let's test this hypothesis and see, how much does it withstand scrutiny? And I believe the best way to understand this entire discourse is to appreciate the historical context in which India started entering into BITs and its interactions with international investment law. So my job is made easy because there's an excellent book by Dr. Prabhas Ranjan on India and bilateral investment treaties, which discusses in 3 phases how India's interaction with ISDS began post its independence in 1947. Now, Dr. Ranjan divides it into 3 phases, and the first phase is between 1947 to 1966, which is the Nehruvian era, and I think that's the most important to understand because there was a visible economic policy and a foreign policy towards investments that was in place. Now, India did not sign any BITs at that point of time, and there was a socialist outlook involving nationalization of a lot of industries. Yet at the same time, India remained receptive to foreign investors, and specifically, even though it did not sign BITs, assurances were made to foreign investors saying that their investments would not be touched as part of the nationalization drive, or if nationalization is unavoidable, there was an assurance regarding the payment of compensation. Likewise, India participated in the drafting of the ICSID Convention, which came in 1965, but it did not accept the convention. India made multiple proposals. India was a willing participant, but at the end of the day, India had reservations that the convention provided foreign investors certain additional rights of unspecified scope, and something we discussed before, it did not impose any countervailing obligations on them. So, in the beginning, the Nehruvian era, India's approach wasn't protectionist per se, but as Prabhas Ranjan describes it, India welcomed foreign investment, but on mutually advantageous terms. Now, in the second phase, which is from 1966 to 1990s, all this changed, or at least changed a lot to under the Indira Gandhi regime, where there were certain populist measures and foreign investment, attracting foreign investment was not the most important priority for the government. And there was a dip also in the incoming investment during that period. The third most important, I think that's critical, is in the 1990s, post 1990s, when India liberalized its economy, there was a desperate need to attract foreign investment. It was in these circumstances that India began to sign bilateral investment treaties left, right, and center. And many of these treaties were actually signed with capital exporting countries. At that point of time, it wasn't conceivable that a lot of Indian investors would be making investment in other countries. The objective was that a lot of other countries, investors from other countries, should be provided an appropriate and welcoming framework to invest in India. And India was not the only one doing that. I mean, the same trend was being witnessed in countries that emerged after the breakup of the Soviet Union around the same point of time. So crucially, when we talk about India's BITs, it's important that almost all of these BITs were signed at a time where India was in desperate need for foreign investment. It had just liberalized the economy. It did not have much bargaining power, and therefore it accepted whatever terms that were imposed on it without much negotiations. At that point of time, it's also relevant, and that's true for all countries. I think Rohan mentioned one of the first treaties with ISDS mechanism was signed in 1968 or 69. But what is overlooked is that the investment treaty arbitration cases started emerging in regular intervals only from 1990s. At that point of time, when many countries were signing BITs, there was minimal or absolutely no jurisprudence on what is the content of these treaty standards. What is meant by fair and equitable? What are the standards for giving fair and reasonable compensation in case of in expropriation of a foreign investment? So it was in these circumstances that there was a lot of mutual trust involved when agreeing to these BITs, not knowing how these standards would be interpreted. In the Indian context, everything was going well, and there wasn't much conversation about international investment law. In fact, India continued to negotiate and sign BITs in 2009, 2010 with Japan and Korea, comprehensive economic partnership agreements. But all that changed from the India's perspective in 2011, when a particular decision in white industries versus India became public, in which India was held liable to pay damages on account of the failure of Indian courts to enforce a commercial arbitration award that was held by the investor for a period of almost a decade. This was found to be in violation of the Indo-Australia BIT, if I'm correct. Now, what did this decision do? Contrary to what many believe, it wasn't a situation that there was one adverse decision against India and then India decided it's going to abandon the ISDS framework. It wasn't like that. What the decision did do is it triggered a conversation. It triggered a discussion within the government to review, for the first time since 1990s, to review what are the treaty obligations that India has signed, what is their true import, what sort of conduct may violate those in the future, and is India well equipped to handle any ISDS cases that are filed against it either right now or in the future. It's on the basis of these discussions that certain findings were made or certain aspects were discovered. And what were these findings? Well, firstly, it was largely perceived that the previous generation BIT signed by India in the 1990s onwards, at a time when India did not have much bargaining power, provided for excessive protection to foreign investors, and crucially, they provided very minimal exceptions to the host state, either on matters of jurisdiction or in case of liability arising out of public welfare measures. The second finding was that since then, a lot of investment awards and decisions were rendered, which ideally would have added clarity as to the meaning of these investment standard protections. But that was not the case. In the absence of a doctrine of precedence, there was all issues of investment law were interpreted in a scattered, vague, and inconsistent manner. For example, there's a running joke in the ISDS community, at least the one I'm part of, where you can potentially pick any investment standards and find 2 or 3 varying interpretations of it and pick one which meets your interest. So it's in these circumstances, India came to a conclusion that, and on top of it, there were legitimacy concerns as well that were discovered by India and many other countries from the global south. By legitimacy here, I mean that any institution must reflect the audience that it caters to or audience that it governs. Now, in theory, while ISDS catered to the entire world, the global north and the global south, the prominent arbitrators, academicians, councils all belong to the global north, that is European jurisdictions or US or Canada. Now, it's based on all these factors and many other, India came to a conclusion that the BITs it had executed in the past did not provide a stable, a predictable, or a balanced mechanism for protection of foreign investment. It was also a situation that more and more Indian investors were now investing in other countries. And it's on this basis it sanctioned a law commission report and expert consultations that ultimately led to the model Indian BIT of 2016. Now, the question was what to do with the existing treaties. I think the first endeavor made by India was simply to reach out to other contracting parties and try to agree to a joint interpretative note explaining or narrowing down the meaning of treaty protections that have been included in India's treaties. That was unsuccessful. Some of the countries said yes, most of them said no. Thereby, like many other countries from Latin America or what we discussed about the EU doing this year, India adopted a reform-based approach. The first step of which was to terminate the 58 or so BITs in 2017, knowing that almost all of those treaties can contain a sunset provision, meaning that the protections guaranteed therein will continue for another 10 or 15 years. And at the same time, try to use the model BIT to enter into new treaties. I think the progress has been slow, but India has entered into 3 treaties since then, 2 of which contain ISDS provisions. As a backup to that, even early this year, the Ministry of Finance has circulated a draft proposal for a domestic investment law, so that even if India is not able to sign a lot of treaties, then investment protection can be provided for in similar terms on the basis of a domestic law. All these factors together reveal one thing, that it would be unfair to say that India's approach towards ISDS has been protectionist per se. As ironic as it may sound, I would say in the current political climate, India seems to have adopted a cautiously welcoming policy towards foreign investment as it existed during the Nehruvian era, which welcomed foreign investment, but on what Prabhas Ranjan says, mutually advantageous terms. India wants its treaties to reflect its bargaining power, just like its treaties executed in the 1990s reflect a clear lack of bargaining power. And when viewed from this perspective, the question that arises is that if not protectionist, what is India's approach towards ISDS? Because it's not in completely favor of ISDS. That's also would be an incorrect statement to say. I think India's approach towards right now, India is cautiously distrusting of international investment treaty law framework, and particularly ISDS as it exists today. And therefore, the endeavor is to create better content so that ISDS becomes acceptable to India and many countries from global south in the longer run. And therefore, the question to be framed is not whether a particular country's approach towards investment law is liberal or precautionary or protectionist, my apologies, but also whether the ISDS and the international investment law framework has done enough to earn the trust of many of these countries, especially considering I don't think anyone in international investment law community would say that ISDS is without its flaws. There are ample talks of reforms. So the question would be whether these reforms are good enough to earn back the trust of countries like India.
Thank you, sir. Mr. Pathak, can you shed a little bit? Can you shed a little light on the treatment that India is according to China and Chinese investors, whether it be the 59 Chinese apps that India has banned recently?
Right. Well, there are two ways to look at it. I mean, as far there is an India-China BIT in question, and I would not think there'll be too many hurdles if a Chinese investor, either direct or indirect investor, would say that these measures allow it to bring a treaty claim against India. Now, the question is whether such claims would be successful. I think that's the key question here. To understand this, one needs to look at the reasons why these measures were taken. And from what's available in the public domain and few things written about it, it appears there are two primary concerns that India had which necessitated or at least motivated these measures. One concerns national security. It's like a form of a countermeasure or measures taken in the context of the deteriorating relations with China. But what's stated as a measure in the PIB press releases, for example, are the privacy concerns, and whether 58 or 59 Chinese apps are doing enough to protect the data of Indian citizens. Now, I believe both of them provide ample justification. Depends on the specific nature of the claim brought forth, but it's not to say that there isn't basis for India to say that therefore it would be able to repel treaty claims on either of the two bases. But what's important to know, and again, it comes back to the point that Ben made about the politics involved in this. Now, we've seen in the past that even the big companies like Facebook and Google have struggled wherever issues of privacy and data protection have brought up, and it's affected their public image a lot. So if this is an anticipated defense that India can expect to take, whether successfully or not, I believe potential investors would be mindful of the fact that would they want an investment treaty tribunal? Would they want a potentially public award to also look into whether these companies are doing enough to protect the privacy concerns of citizens of a particular country? Looked at from this perspective, even though there may be jurisdictional basis to bring about a treaty claim, then on an overall assessment of it, I would say there's a reason why we've seen some noise, but we haven't seen a lot of noise as we had seen with respect to some other measures about India risking a lot of investment treaty claims. So it's a difficult one. I think time will give the best answer, but claims can be brought, and I think there's ample basis for claims to be repelled as well.
Mr. Giaretta, do you have anything to add to this?
I don't think I could. I mean, that was such an excellent explanation of the situation in India. I might just add one point, just by way of clarification for some of the people who are watching this. When we talk about ISDS, we're actually talking about two things there. One is the substantive protections found in the treaties, and the second is the method by which those protections are enforced, i.e. the investment treaty arbitrations and the tribunals. And both of these two things have benefits, and they also have disadvantages. So the substantive protections that are provided ensure, promote the rule of law across the world, which is a good thing, absolutely. But sometimes it may appear that the foreign investor has more rights than the domestic investor, and that is obviously can cause a lot of difficulties in country. And investment treaty tribunals are a good thing because they are neutral and promote a high standard of dispute resolution. On the other hand, they are private, and there have been criticisms of certain tribunal members, certain arbitrators, for bias, for not doing their job very well, and that those criticisms have reflected badly on the corpus of arbitrators as a whole. So I just wanted to make that point clear for the people listening, that we're actually talking about many things when we are referring to ISDS. And you can split those things up. I mean, this is what the EU is trying to do at the moment. It's trying to take the protections offered under bilateral investment treaties and change the enforcement mechanism, so to move them into a public court system. And equally, one could change the substantive measures, but keep the enforcement mechanism within investment treaty arbitration. So this is the multi-layered topic we're talking about here.
Thank you, sir. Panelists, I think we're short on time. So can anyone volunteer to conclude on the theme of the webinar?
I mean, in terms of the title of this, reassertion of control, I mean, it makes it sound like it's a bad thing. I don't think it is at all. I mean, what we're seeing is the development of investment treaty protections, investment treaty arbitrations. And yes, of course, some developments can be bad, but development can be a very good thing. And in fact, we may see some tremendous improvements that come about through this changing attitudes of governments towards investment treaties. In many ways, I think what we're seeing now is governments becoming alive to the nature of investment treaties in a way they weren't 20 years ago, and that could well be a good thing, and it could promote the rule of law, could promote investment across the world, and give parties greater confidence if they know that the governments actually know what they're talking about. It very much felt in the past that the governments were caught by surprise on some of these investment treaty claims. But now governments are going into taking actions, being aware of the possibility of investment treaty claims.
Thank you, Mr. Giaretta. Let's quickly move to the questions by our viewers. The first question is addressed to Mr. Pathak. You pointed out that it is better to have a balanced and bargained ISDS provisions in the BIT, but wasn't the idea of having BITs was primarily to provide protections to the investors and not give deference to host states when it comes to their actions?
Right. Well, there are two ways to look at it. What you said was definitely the idea behind investment treaties to begin with, and in the larger context, it does remain the idea, because it cannot be denied that in most cases there is an imbalance between the state where the investment is made and a foreign investor who's new to the particular surroundings. That being said, there have been decisions, interpretations, which many have criticized, investment decisions, which many have criticized as saying that they create a regulatory chill, meaning that every time a state decides to take a decision which will have economic ramifications for foreign investors, there is a looming threat of a BIT claim, which can result in a lot of compensation to be paid. So in that situation, if the criticism now that emerges is that this regulatory chill and the propensity of tribunals to find in favor of investors, although that's not verified completely, has created a new imbalance, this time in favor of the investors. And it's this additional imbalance, therefore, that in the views of many states needs to be restored. The second aspect to that is that one may very well question whether the imbalance between a foreign investor and state exists in all cases to begin with. And a prominent case is Philip Morris versus Uruguay, where Uruguay's measures with respect to restricting the advertising on cigarettes as a public health measure were the subject of a challenge, and that's perfectly fine. An investment tribunal did reject such a challenge. But during the proceedings, it emerged that the resources that Philip Morris had employed in terms of its legal team, the experts on record, were far more than what Uruguay had to contribute to its legal team. So it allowed many people to question that here is a situation where you have a developing state financially being outmatched by an investor who's actually a global powerhouse. So it's from these two perspectives that people now are looking at BITs and saying, and rediscovering what sort of balance needs to be created. It's no longer as simple in the globalized world like today as saying that it's not a David versus Goliath battle anymore in all cases uniformly.
Thank you, Mr. Pathak. We have another question, and this is open to all our panelists. The question is, can we see governments entering into mutual agreements suspending BIT obligations for the period of the pandemic, or directing their investors not to bring claims against the countries?
Well, I think I commented on this earlier. There has been some discussion about suspending BITs during this period, but it becomes very political, particularly when we're talking about BITs, so they're bilateral between two countries. You'd have to have both countries agreeing to it, and one government then may expose themselves to criticism later down the line. Also, a lot of these criticisms, a lot of these proposals to suspend BITs seem to come from a political point of view that opposes all BITs in the first place, and very much want to throw the baby out with the bathwater. They want to get rid of the whole lot, good thing, all the good and bad that comes with it, and that's a fair enough point of view. I'm not criticizing that here particularly, but it does seem to be that some of these proposals are disguised attempts just to get rid of the whole system entirely. I mean, I would think it's very unlikely that governments would agree to this at the current time, because they won't want to be seen to be reneging on their promises. They won't want to be seen to be taking such action that might damage the investors of other countries at this current time. But also tied up in that calculation will be an assessment by the government, a correct assessment, I believe, that it's very unlikely that claims will be brought at the current time. Now, things may change next year, as already indicated, when we start to see some of these claims come through. And in particular, if we haven't had what they call a V-shaped recovery, so we haven't had an immediate bounce back. If countries are still in very difficult economic circumstances next year, you may then, and they're facing some of these claims, you may then find that they try to unwind some of their BITs. But generally speaking, these BITs have sunset clauses, which means that they stay, although they may be cancelled relatively quickly, the effects upon existing investments may continue. So there may be still possibilities of bringing these claims in the future. So it may not do them much good, in fact, to suspend the BITs next year in reaction to a few claims that come along. I mean, changes to these systems take a long time to be brought into force, and a number of years. And it's very difficult, I think, for any knee-jerk action to be taken in response to prevailing circumstances, which again might be another criticism of them, that they are difficult to change.
Mr. Giaretta, the next question is also for you. The potential liability of the state which has failed to take adequate regulatory methods to control the spread of the virus or rehabilitate the economy, which has been worsened, or regulate the infections in a company's enterprise. Can an action be taken against a state for that?
Well, I mean, yeah, possibly in theory, and it's a very interesting question. I mean, let's take the British government, for example, who have faced criticism for not shutting down the economy earlier, for not locking down the country earlier than they did. One could see a possible claim be brought against them for failing to protect the safety of the foreign investors who have come to this country and invested in this country. On the other hand, the government could well say, well, we were following the advice of the scientists, and that's what we did. And so we acted perfectly reasonably. But even more, they could say this is entirely new. No one knew what to do. And no one knows still whether they did the right thing or the wrong thing. Yes, there was in Britain, there was an immediate impact, and the death rates went up terribly immediately. But who's to say longer term it may have proved to be the right thing to do? I mean, back in March, the government were talking about the population obtaining what they called a herd immunity, whereby by exposing people to the disease, it'll build up immune levels very quickly. Perhaps that will happen. I don't know. I'm not a scientist. It's drawing out a criticism and bringing a claim against governments on these public health grounds is going to be enormously difficult. So while in theory it might be possible, I really can't see anyone doing it in practice. I think it's much more likely, as I've said, that you'll see claims relating to the economic steps that are being taken now and that will come in the future, and also perhaps attempts to criticize, to uncover the true motives for certain actions. But when it looks at purely public health actions, I just can't see anyone in practice bringing such a claim.
Thank you, sir. I think we'll take 2 more questions. Now, the next question is addressed to Mr. Nayak. The question basically asks what the nature of a joint interpretation is. Is it of the nature of an amendment so that it is applied only prospectively, or is it of a nature of a clarification so that it can be applied retrospectively as well?
To the best of my knowledge, it would these joint determination procedures are usually in the nature of setting out specific rules for declaratory disputes, insofar as they set down certain standards according to which the reliefs would be determined. As far as I know, they apply they apply prospectively from the date on which they are made. But I'm subject to correction by my other co-panelists in this regard.
Right. I was just, I think I agree with what Rohan said. And just add on to it slightly that there are specific rules and conventions for interpretation of treaties. There's something called the Vienna Convention of Law of Treaties, which although India hasn't signed, but it's considered part of customary international law. So those rules for interpreting treaties exist. Within that framework, a joint interpretative note issued by both or all contracting parties to a particular treaty, it has a more clarificatory nature. It expounds the object and the purpose of each specific provision, and therefore provides appropriate context so that the treaty can be interpreted in a manner consistent with these customary rules. Now, for example, I just opened in front of me the joint interpretative note that was issued by India and Bangladesh with respect to their treaty, and it says that it was issued taking into account the power of the contracting parties to provide clarification on the object and purpose of the agreement. So I think what the interpretative note itself says is also determinative of its character, but an amendment would be slightly different than that.
Thank you, Mr. Pathak. We now move on to the last question, and this is again addressed to Mr. Pathak. The question is, to what extent Mr. Pathak thinks that the Indian model BIT will be capable in defending COVID-19 inspired claims in the near future?
Well, I mean, a simple answer to that question would be that it's a model Indian BIT. If India is not able to sign new treaties which have provisions similar to the model Indian BIT, then it has absolutely no utility. The hope is that India would be able to sign treaties. That being said, I think the one improvement that's been made by the model Indian BIT is that it has tried, let me be very clear, there's a lot to criticize the model Indian BIT as well, and a lot of scholars have written about it, and all that criticism is very well justified. but there's a lot to appreciate as well. In the context of COVID-19, for example, I think one of the good things that the model Indian BIT has done is that it's tried to limit the vague interpretative standards, such as the fair and equitable treatment standards, which tribunals have given inconsistent interpretation to in the past. They've replaced them with narrow standards with respect to treatment of investment, which by itself should limit the ambiguities or the vagueness that's otherwise inherent in investment jurisprudence. On top of it, certain provisions, like I think the Indian model BIT is one of the first or one of the few treaty instruments, model BITs to put it that way, which recognizes the police powers doctrine, which essentially allows a state an escape from liability where it has taken non-discriminatory public welfare measures. Now, if these sort of provisions, there's a lot of discussion about police powers doctrine, and some tribunals accept it, some don't. But if these sort of provisions exist in treaties that India may sign in the future, then it has, I mean, I agree with everything Ben said. It's difficult to say what sort of claims would emerge out of a COVID-19 sort of pandemic. But if such claims emerge, then there are good way outs, escape routes in the language of the treaty itself that India or any state then can rely upon.
I think I'm muted, Rashika.
Yes, I also can't hear you.
I'm extremely sorry for that. Since we're out of time, we'll have to end our Q&A session here. I would like to thank all our viewers for tuning in today and sending us all the questions, although all of those questions could not be addressed due to paucity of time. I would like to thank our speakers, Mr. Giaretta, Mr. Nayak, and Mr. Pathak for the extremely engaging session. They not only agreed to take the session, but they also provided us provided us valuable suggestions to improve the webinar. We hope to continue to have your support and encouragement in the future as well. I would also like to thank our Vice Chancellor and Professor Kundu for giving us this platform and for always being the guiding force in our endeavors. Lastly, we would thank our media partners, Bar and Bench. And I think that will be all. Thank you so much.
Thank you.
Thank you.
Thank you.